So, thank you so much for joining us, everyone. Good evening, and welcome to the launch of State of Denial, the new report from the Australian Climate Accountability Project of the Australian Human Rights Institute at UNSW. My name is Maria Nawaz, and I'm the project lead at the Australian Climate Accountability Project. I'll begin by acknowledging the traditional owners of the land on which I'm speaking, the Gadigal people of the Eora Nation. I pay my respects to elders past and present and to any First Nations people joining us today. In the context of what we'll be discussing today, it's important to acknowledge that First Nations communities around Australia are at the front line of experiencing climate extremes and are facing devastated and unprecedented human rights harms, including loss of culture due to sea level rise. State of Denial examines Australia's legal obligations for human rights harms occurring within Australia as a result of its fossil fuel exports. As one of the world's leading fossil fuel exporters, Australia's responsibilities in the climate crisis are under increasing scrutiny. Our discussion tonight will consider some key questions. What are Australia's legal obligations in this critical decade for climate action? How are Australia's exported fossil fuel emissions driving human rights harms here at home? And what does the International Court of Justice's recent advisory opinion on climate change mean for Australia and for domestic climate litigation in Australia? It is a privilege to be joined by our distinguished panel of speakers this evening. Each brings deep expertise and unique insight to these questions. We're joined by Jennifer Robinson, who is an award-winning barrister at Doughty Street Chambers in London. She specialises in international law, human rights law, and media law. Jen has acted in cases in the UK, successfully challenging the government's policy on fracking on climate grounds and overturning unprecedented injunctions targeting peaceful climate protest. Jennifer advised Vanuatu throughout its successful campaign to have the General Assembly request an advisory opinion from the International Court of Justice on the obligations of states in respect of climate change. She also acted for Vanuatu and the Marshall Islands in the proceedings before the International Court of Justice. Jen sits on the board of Grata Fund, which supports public interest litigation, including the Australian climate case brought by Uncle Papai and Uncle Paul against the Australian government. Tonight, we're also joined by Gillian Moon, who is a senior visiting fellow at UNSW Law and Justice, where she has held academic roles since 2003. She is the founder and research lead at the Australian Climate Accountability Project of the Australian Human Rights Institute, UNSW. She has taught, researched, and published widely in human rights law, particularly its intersections with international economic law, international climate law, and development theory. She has previously practiced in public interest law, has experience in policy formulation and law reform, and was an advisor to Commonwealth Ministers for Justice and Consumer Affairs in Canberra. In 2024, she released groundbreaking research entitled Escalation, which examined the total life cycle of carbon emissions for Australia's fossil fuel exports. We're also joined by Nathan Kennedy, who is a legal practitioner with over 25 years of experience. Nathan holds an LLM in Human Rights and Social Justice from the University of New South Wales. He was a member of the National Committee of Australian Lawyers for Human Rights for almost 10 years, including holding the position of president for 2 years. He served on the Australian Human Rights Institute's Advisory Committee from 2021 to 2025. Nathan has practical experience with United Nations human rights processes, including having presented to the United Nations Committee on the Rights of the Child. He has volunteered and worked with community legal centres for 16 years, acquiring experience in a wide variety of legal areas. Nathan was previously a board member of the Great Lakes Agency for Peace and Development, a not-for-profit organisation helping migrants, refugees and asylum seekers from Africa settle in Australia. And finally, we're joined by Dr. Chris McGrath, who is an environmental lawyer practicing in climate and human rights law. Over the past 20 years, he has acted as counsel in many Australian cases against large coal mines challenging their contribution to climate change. His website, Environmental Law Australia, provides case studies of many leading Australian climate cases. He's an adjunct associate professor in the School of the Environment at the University of Queensland. His current research focuses on strategic climate litigation opportunities in the Pacific. So thank you very much for joining us tonight. We might go to Jen first. Jen, could you share your experience representing Vanuatu before the International Court of Justice and reflect on what the advisory opinion might mean for Australia?
Sure. Thank you, Maria, and thank you to UNSW for this important report and for inviting us all this evening. First, before I start, obviously, I would like to pay my respects to the traditional owners of the land where our hosts are at UNSW, the Bidjigal people, but also the traditional owners of the land from wherever you're joining us from, and pay my respects to elders past, present, and future. I also want to acknowledge the disproportionate impact that climate change is having on First Nations communities in Australia and around the world, as well as the importance of the role of First Nations knowledge and wisdom in combating climate change, and how important it is that we centre that knowledge and experience in our responses. So I'm very happy to speak today about the ICJ decision, which we're obviously thrilled with in terms of what it means for Vanuatu and Marshall Islands, the governments that I represented in the proceedings, but also for the world and for Australia. And I just want to acknowledge too, in acknowledging First Nations people and traditional owners of the land, that this case would never have happened if it weren't for Vanuatu and other Pacific countries leading the charge, because of the impacts on Indigenous peoples across the Pacific, and how heavily the evidence of that impact played in the court, and I think affected the court's decision and influenced the strong decision that we got from the court. So today I want to address 3 points. I want to talk a little bit about the process in this case, having been involved with Vanuatu since the very beginning, on how unprecedented these proceedings are, how they came about, and how I think that affected the outcome in the court and why we got such a strong response. Give you an outline of the key findings.
I think we may have lost Jen then. We'll just hope that her internet comes back online. Jen, can you hear us?
I can hear you fine. Can you hear me okay?
Yes, we can now.
I'm sorry about this. I'm not sure where you heard me from, but I was asked to join the team for Vanuatu about 5 years ago, having acted for Vanuatu in their first appearance before the International Court in the Chagos Island proceedings. And the aim in seeking this advisory opinion, it was something that had been mooted academically as a potential opportunity before the court. But of course, advisory opinion proceedings are incredibly difficult because of the politics that you need to get.
I think we've just lost Jen there again. Poor Jen's joining us from overseas. Jen, we've got you back. You've just said, of course, what you need to get an advisory opinion is. That's what we heard.
Let me see if I can switch Wi-Fi and see if it makes it any easier.
Sure.
Can you hear me okay?
Yes, we can.
Okay. Of course, the idea of an advisory opinion proceedings on climate change had been something that was discussed academically, but politically it was seen as impossible because of the requirement to seek to get a majority of the General Assembly to get a resolution like this through to refer the matter to the court. Little Vanuatu, started by a group of 27 students out in the Pacific, made this a priority because of the impact they were seeing at home. And little Vanuatu pulled off a diplomatic coup that no other superpower has ever pulled off in getting this through the General Assembly by consensus without even requiring a vote. So it was unprecedented in the manner in which it became before the proceedings. It's a case we've been working on for 5 years to get it there. It was a huge diplomatic effort by Vanuatu. And it was unprecedented in terms of the participation of states. It's the biggest advisory proceedings we've ever seen before the court and the most representative. So we've seen a number of countries, particularly Latin American countries, Pacific Island countries, and Caribbean countries, coming to the court for the first time ever, representing their countries. So we saw a huge number of governments who stood up before the court giving evidence about the impact of climate change in their countries. And as a lawyer who sat through those proceedings and was there for the whole duration, the impact on the court of hearing government after government stand up and speak about the devastating economic and environmental and social impact on their country of climate change left the court in no doubt of its historical responsibility in this case. And I think that's why we see the decision that we received, because of the impact of those proceedings, and the impact of the number of states that turned up before the court. I also want to recognise Vanuatu, and in particular Ralph Regenvanu, who was the climate envoy and previously the foreign minister of Vanuatu, who was really the driving force behind getting this case heard. Two other key parts of the process that I wanted to highlight is the fact that we had so much lived experience of frontline communities brought to the court. And that was a key priority for Vanuatu and a testament to the approach that Ralph Regenvanu wanted to see, but also led by Indigenous Pacific lawyer Julian Arguan and Blue Ocean Law. And I pay tribute to my colleagues who I worked with in that case and the remarkable work they did in gathering testimony from around the Pacific. Another important part of the process that I think we need to recognise as having driven the opinion is the role of climate science. So it's significant that the International Court of Justice invited the IPCC to come and give a presentation to the court about the science before the hearing started. But I can also say, as counsel before the court, that the impact that we saw on the judges through the presentation of scientific modelling from different countries, but in particular, I think, and perhaps I'm biased because I acted for them, from the Marshall Islands, it was palpable, the response from the court in the room. So thanks to the work that was done by the South Pacific community, the SPC, in helping Pacific Island states develop science and modelling around the impact of climate change, we were able to present on behalf of Marshall Islands some scientific modelling that showed the effect of sea level rise at 1.5 degrees of temperature rise, the projected sea level rise, and the impact that that would have. And showing that to the court, showing how that these sea level inundations would happen 10 times more frequently with 10 times the intensity, inundating most of the island major infrastructure, food and water sources, at a frequency that effectively would render Marshall Islands inhabitable. You could hear an audible gasp from some of the judges when that modelling was shown in court. And I really do think that that had an impact on the court's findings, which I'll talk about in a moment, in particular in respect to having to meet that 1.5 degrees target. So I think these factors came together, both the strength of the numbers of governments that came together, the sheer weight of legal opinion from the number of governments who turned up. The great majority of states supported the arguments that we put forward as Vanuatu as the lead state. Countries like Australia, Saudi Arabia, the US, China, and Russia were definitely outliers in the legal positions that were put before the court. And what is so exciting is that the ICJ rendered an opinion which shut down those arguments and made clear what states' obligations are. So we were thrilled with the outcome. And so just to secondly outline for you some of the key findings from the court. The goal that we had as the government of Vanuatu was to clarify states' obligations to drive stronger action, because Pacific Island states are so frustrated by the complete failure, effectively, of COP and climate negotiations to render the action required and the support in terms of adaptation measures and funding for those adaptation measures that Pacific Island states and small island developing states like Vanuatu are entitled to. We all agree they should get it, but they're not getting it fast enough. The action's not happening fast enough. The funding is not coming through, and they are left with the consequences. And I'm thrilled to say that the findings of the court will absolutely have an impact on driving more ambitious climate action if states are going to be complying with their international obligations. So the first key finding, which was really one that we said was not from a straightforward legal point of view, the submissions that we made for Vanuatu were a straightforward application of existing customary international law. We simply asked the court to apply customary international law on environment as it relates to the duty to prevent significant harm and the duty to prevent transboundary harm, that those obligations apply in the context of climate change. And that, to me, was not a radical position to adopt unless you're Australia. And it was all too difficult to this very complicated problem of climate change. We can't possibly apply the principles of law to a new set of facts. That would be all too difficult. And of course, the court said that is utter nonsense. So all states have a binding obligation to take action to stop climate change and to protect the climate system. And that means to limit, as the court found, global warming to 1.5 degrees. And this is a duty of strict due diligence. That was the unanimous decision of the court. Now, this is important because of the recognition of climate science and that 1.5 degrees is actually not safe for most nations, including countries like Marshall Islands, but that this is the consensus target under international law and required by customary international law. And this is important for anyone who's been at climate negotiations because not all governments have been aiming towards this temperature goal, and their targets have not aimed towards this temperature goal. So this is a significant win for the Pacific and for small island states. The court rejected the arguments of Australia, the US, Saudi Arabia, and other big emitting states saying that climate treaties are lex specialis. That was a unanimous finding as well. So it's not sufficient to say that while the court found good faith compliance with obligations under climate treaties can amount to compliance with your customary international law obligations, it doesn't necessarily mean that. So these are distinct and separate obligations, and the climate treaties, complying with your climate treaty obligations will not necessarily mean you meet customary international law obligations to meet that 1.5 standard. I think that this is looking at the climate treaty obligations. What the court also made clear is that you have countries like Australia and the US and Saudi Arabia saying, well, climate obligations are whatever we say they are under these treaties. And the court says, no, that's not correct. You don't have a complete discretion in determining your national determined contributions. You must take action compliant with customary international law, setting 1.5 degrees as your baseline. The strict due diligence obligation applies to that, and you must consistently tighten commitments, taking into account your historical emissions. I think what's very interesting about this is some of the comments made by judges, and particularly I like the Cleveland Bandari Joint Declaration, which talks more specifically about what these obligations look like, which is stopping the production of fossil fuels, transition away from fossil fuel production, and to stop subsidizing fossil fuel production. And that most developed and high emitting states have to make deeper and faster cuts, and that includes Australia. I just want to touch on three other key findings that are very important for the Pacific. The first being sea level rise and statehood. So the court made clear that there's a presumption of continued statehood if territory disappears as a result of sea level rise. Now, this was a very limited discussion, and I recommend Orescu's separate opinion on that, how it could have been better. But for the majority of Pacific Island states, well, for all Pacific Island states, this is a massive priority, which will have significant impacts on ongoing negotiations in the region associated with sea level rise and boundaries. For me as a human rights lawyer, the human rights findings are important, but of course we've already had significant rulings from the European Court of Human Rights, from the Inter-American Court of Human Rights, setting out what states' human rights obligations are with respect to climate change. But as our great judge, Justice Hilary Charlesworth, set out in her opinion, this will have an important procedural contribution in terms of broadening access to dispute resolution procedures and standings for individual rights holders. But of course, importantly, the court found the existence of the right to a clean and healthy environment as a human rights under international law. Of course, we've been edging towards that as an international finding, but having the International Court set that out clearly is an important international law development. One disappointment I have is that they didn't make clear the customary international law status of that right. But I think if you look at Orescu's separate opinion, he sets that out in detail, and it is, I believe, implied by what the court said. If you recognise that all of these human rights, many of these human rights are protected as a matter of customary international law, and the right to a clean and healthy environment is implicit and is required in order to comply with those rights, then by implication, this ought to be a right of customary international law status. Just finally, I think just two quick last points about non-refoulement, which is a really important one for the Pacific too, that the protection of non-refoulement applies in the context of climate change. This was a priority for a number of Pacific Island states, that it was a problem that was not a basis for refugee entitlement previously, and the court recognised that it is. So very important. A few words on impact, because I don't want to take up too much more time and allow our other speakers to talk about it. But from our point of view, this decision did everything that we wanted it to do. The court made clear states' customary international law obligations, made clear that 1.5 degrees needs to be the target, made clear that there are international human rights obligations that apply to climate change, made clear that states have to phase out fossil fuels, that these are binding obligations on every government, irrespective of their participation in the climate treaty system. This is going to have a massive impact as the highest court in the world, as the key judicial organ of the United Nations system. This is the most authoritative decision that we've had on climate change and international law, and it will inform domestic, regional, and international litigation around the world. We're already seeing its impact in the conversations around states setting their nationally determined contributions, and I think we're going to see it feature further in future climate negotiations and also in litigation. So it's significant for us as Australians that this decision came down just shortly after the Australian climate case, which was taken, as Maria mentioned, by Uncle Paul and Uncle Pubbo and funded by the Grata Fund, of which I'm a board member. I think what the ICJ decision shows is how out of step Australian laws and our courts are when it comes to climate change. And I hope that the ICJ decision gives impetus both to our Parliament, but also to our courts, including in the Australian climate case, about moving the needle when it comes to climate change in Australian law and in the Australian courts. So finally, I just want to say I am proud to serve as a board member of the Grata Fund, and I'm proud that we're funding that case, and I hope we see a different outcome on appeal. And I'm very proud to serve as an advisory board member of the Australian Human Rights Institute and of this report, which I think sets down a roadmap about, for me, one of the most exciting things is to see how this decision is now going to be implemented at home in Australia and how we can use it to hold our government to account to push for more ambitious climate action to protect our country. So thank you for inviting me. I look forward to hearing from Gillian, Nathan, and Chris on what more we can do at home.
Thanks so much, Jen, particularly for those valuable insights and the insider account of the ICJ decision and what it might mean for Australia. We'll now talk to Gillian, one of the co-authors of State of Denial. Gillian, could you walk us through Australia's fossil fuel exports and their role in driving global warming?
Yes. Thanks, Maria, and also Jen for capturing the significance of the ICJ advisory opinion so powerfully. I'm going to wind back a bit and go back to the facts about Australia's role as a fossil fuel exporter. So Australia's greatest contribution by far to climate change is its fossil fuel exports. The vast quantities of coal we've been exporting since the 1960s, plus now all the gas and even some oil that we're exporting too. But when our project was conceived in the Australian Human Rights Institute at UNSW nearly 3 years ago, there wasn't a huge amount of information available about them. We just knew that they were very large. And we also knew that Australia was successfully presenting as a state taking its Paris Agreement obligations seriously. It pursues policies and programs directed at reducing its domestic emissions. It has domestic decarbonisation targets and timelines, and it complies with its emission reporting obligations to the UNFCCC. But Australia is also a big fossil fuel producer. And while the emissions within Australia from fossil fuel production and use are only around 1% of global, the life cycle carbon emission of its fossil fuel exports are more than 3 times that. In fact, Australia ranks as the second largest contributor globally to exported fossil fuel life cycle carbon emissions, ahead of the giant United States and of every OPEC state and behind only Russia. State of Denial reveals for the first time that Australia's exported fossil fuel emissions have measurably raised global average temperatures, and the IPCC has repeatedly warned that every single fraction of a degree of warming makes climate hazards and extremes worse, with measurable human consequences for us and for our families, our communities here in Australia. So, we investigated what steps Australia is taking to reduce its fossil fuel exports, and we found that Australia was and is doing almost nothing. It has no cap or limit on the fossil fuel export volumes. It has no reduction targets for them. It has no plan for addressing reductions in the future. It has no national policy framework on them, and it has no public conversation about whether we want to be continuing along this path. Instead, Australia is regularly approving new coal and gas projects, another one just in the last week, almost all for export and often for decades into the future, and to provide a range of subsidies and supports to the projects, including infrastructure like port facilities. So this is the story of how the report we're launching today, State of Denial, came about. In a world first of its kind, we set out the consequences for people in Australia and their human rights from our own actions, pumping out these quantities of fossil fuels for export. And we close the loop, in a sense, to show that these actions have very much unwanted consequences for us here in Australia. In State of Denial, we set out the facts about the climate damage our exports are making worse and about the consequent human and human rights harms as the climate we've known deteriorates. My co-author of State of Denial, Nathan, will explain that these harms are already upon us, they're escalating, and they're effectively permanent on human timescales. Nathan.
Thanks very much, Gillian. Yeah, so we wanted to look at the information gap about the way climate-driven human harms are in Australia and the evidence that they're being made worse due to our fossil fuel exports. And we had a look at secondary research here and looked particularly at increasing heat and the evidence of the risks this poses to people. And we've set out in the report the main heat-related findings and projections on excess and premature deaths in Australia. And deaths from excess heat are still very much under-recorded in Australia, but new data is starting to come through more strongly lately, and there's some research of environmental economist Tom Longden at ANU in relation to this. And we also drew together the main research identifying the demographic and geographic characteristics of people assessed to be at greater risk from additional heat. The geographic standout characteristic for urban heat risk is undoubtedly living in a heat island, but living in areas with rising heat and humidity together is also a lethal threat, particularly for northern parts of Australia. Significant among the demographic groups at heightened risk were infants and the elderly, people with certain medical conditions, members of First Nations communities, people with lower socioeconomic status, outdoor workers, people with disability, and women, including particularly pregnant women. And risk for people with these characteristics was raised further where there were intersectionalities. For example, people with relevant medical conditions and low incomes living in urban heat islands. We saw too that increasing climate extremes are affecting people's home lives and well-being in a multiplicity of intrusive ways, from dramatic extreme weather intrusions like floods to more frequent smoke periods, fresh food shortages, disruptions to supplies of pharmaceuticals, cancelled outdoor recreation, and more frequent lost workdays for outdoor workers. And we also saw increasing personal curtailments as being necessary for many people if they're to protect themselves from more serious threats, including to their lives from intensifying extreme weather. An example we used was the 11% of people in Australia who live with asthma to illustrate the limits and intrusions on their daily lives and choices, which a worsening climate brings. And as Gillian said, effectively, permanently, with increased risks of certain types of thunderstorms, people with asthma really need to stay inside, and that's the sort of directions that are given by government, and that has a very much a curtailment on how they can live their lives, as well as affecting their health. Another example is very evident from the case of Daniel Billy from 2022 and the recent Pabai decision, with climate change and sea level rise fundamentally damaging the lives, health and cultural practices of people in the Torres Strait. And there are many other ways that, that climate change is affecting people and will increasingly affect them. The IPCC has warned that climate change poses threats to foundational human systems, and many of which provide access to health services, food and water, education, safe housing, energy, and transport. And the IPCC has described strains on human systems from climate changes and increasing extremes as already occurring in Australia. And you can see when you look at these that at the heart of so much of them is human health. And the authors of a major study in The Lancet in July this year noted that destabilising the Earth system through global warming fundamentally threatens human health in irreversible ways and on a very large scale. And all of these human harms are frequently also human rights harms. And we focused our research on two rights in particular, the right to life and the right to family and home life. And the latter of these rights in particular has been given a fairly broad interpretation in human rights jurisprudence, encompassing protection against interference, which takes the form of harms to life, health, well-being, and quality of life. In the case of Daniel Billy, the UN Human Rights Committee concluded that factors weighing strongly in its finding that Australia had violated this right included the destructive effects of climate change on the victims' housing, food sources, and physical and mental health, and interference with them being able to undertake cultural practices. And in the European Court of Human Rights, in their landmark decision of Klima Signorini, the right to family and home life in the European Convention was said to be seen as encompassing a right for individuals to effective protection by the state authorities from serious adverse effects of climate change on their life, health, well-being, and quality of life. And the older women involved in that case had complained not only of direct harms to their health from heat waves, but restrictions on their well-being and their quality of life in being forced, for example, to stay inside to avoid the heat, which they had to do during heat waves brought on by climate change. And you can see that this interference with health and well-being is evident in all the harms that I previously mentioned. But there is some challenges with enforcing these rights. It's interesting to see that there's almost complete overlap between the demographic groups identified in the scientific literature as particularly vulnerable to the harmful impacts of climate change and the groups who are specifically protected under international human rights conventions and declarations, such as women, children, First Nations people with a disability, and possibly in the future, older people, through the Convention on the Rights of Older Persons. And you could say that on its face, the evidence of human harms globally from worsening climate change and extremes more than makes the case that human rights are also being harmed, and the evidence of worsening harms to identifiable demographic and geographic groups in Australia is robust and substantial and growing. This is what we referred to in the report as the general causal case, which we say has now been made out and is growing ever more uncontestable as increasing data on human impacts flows in. And essentially, the chain for this is that an X amount of megatons of CO2 will result in a quantifiable global mean temperature rise, which in turn will result in a quantifiable increase in the probability of specific weather extremes occurring, which will in turn correspond with a quantifiable increase in the likelihood of certain harms to identified demographic and geographic groups. An example would be that for every increase in the number of hot days, there will be responses in terms of adverse birth outcomes, emergency department presentations, and deaths of people with specific medical conditions. But it can be challenging for the threatened people in these groups to assert or enforce their right to protection through the courts or other human rights mechanisms. And this is because establishing what we've called the individual causal case to the level of specificity or proof required by courts or other bodies can still be difficult for many reasons. There are challenges in seeking to extend the factual chain of causation from individual sets of emissions to specific human rights harms experienced by particular individuals. The European Court of Human Rights in Klima Signorini noted that the causation issues include the connection between the range of adverse effects from climate change and the threats from those effects to the enjoyment of human rights, the connection at the individual level between the claimed harm or risk of harm to the claimant and the impugned acts or omissions of the state, and the responsibility attributed to the state for the claimed adverse effects given the multiple sources of aggregate greenhouse gas emissions. And I mean, the recent case of Pabai demonstrated the inherent difficulty in the law of negligence in establishing a direct causal link between in this case, Australia's emissions policies and specific climate impacts, again, particularly given the global and cumulative nature of climate change. Much of the harm from climate change is based on rising probability or risk, as opposed to present injury or even present direct threat. And the uncertainties of that can sometimes make it hard for individuals to meet courts or other bodies' thresholds for standing to bring legal actions as well. The Human Rights Committee in Daniel Billy explained that the right to protection does not extend to hypothetical threats to life, for example. To gain standing and to demonstrate an actual impairment of the right, applicants must face a real and reasonably foreseeable risk of being exposed to physical endangerment or extreme precarity that could threaten their right to life. And that is quite a challenge in enforcing any claim in relation to the right to life. In the European Court of Human Rights in Klima Signorinen, they spoke about victim status criteria, requiring an applicant to demonstrate a personal and direct effect from the state's action and or inaction or insufficient action. And this effect must include a high intensity of exposure to the adverse effects of climate change, as well as revealing a pressing need to ensure the applicant's individual protection owing to the absence or inadequacy of any reasonable measures to reduce the harm. The court acknowledged that the threshold for fulfilling these criteria is especially high, and it will require a close link between victim status and the applicability of the relevant convention provisions. But where individuals might lack standing, there are examples of where associations have been granted standing, even in situations where their individual members or supporters have not. And this arose in Klima Signorinen, where the applicant association had standing, even though the individual applicants did not meet the victim status requirements. And it also arose in a Queensland case of Youth Verdict, which considered an application for approval of a coal mine expansion and its potential impacts on human rights. And the Queensland Land Court held that the objector association was entitled to maintain its objection to the grant of the mining tenement. But there could be further challenges if the persons affected are the population at large. If the group is so large that no one has a special interest for the purposes of standing, the matter might be considered by the courts to be really a matter for the legislature. And it's worth realising really that the international human rights law regime was set up to protect the rights of individuals, so it struggles a bit to accommodate serious threats as from climate extremes to whole sections of a nation's population. When we look at Australia, of course, a real major issue with enforcing rights is a lack of available courses of action at all. There is no Federal Human Rights Act. The Queensland and Victorian Human Rights Acts have no direct human rights cause of action. And PABI, in terms of torts, has again suggested there is maybe no common law duty of care in relation to climate change. So there's clearly a need to address some of these enforcement and remedies problems. But as we've heard a bit about the recent ICJ decision, the good news with that is Australia does have binding international law obligations to protect us, which are not frustrated by these factors. And I'll hand back to Gillian to discuss a bit more about that case.
Thanks, Nathan. So the problems with enforcing the rights don't affect Australia's legal obligations in relation to the harm that it's causing. And so I will circle back to what Jen was talking about now and talk about Australia's legal obligations in relation to the exports and those harms. And I'll do this by mentioning 5 conclusions from that advisory opinion that we've identified in State of Denial as particularly relevant for Australia's international law and human rights law obligations when it comes to the exports. And the first point is simply that, as Jen described, the ICJ went beyond expectations and has now clarified so much of the law that Australia can be in a little doubt as to what its legal obligations are. And while it's an advisory opinion, so not technically binding on Australia, it is the unanimous opinion of the world's most authoritative legal source on the subject. Our second point is that one of the main arguments, and Jen touched on this, which Australia put before the ICJ, has been shown to be completely wrong. So Australia argued that meeting the quite limited procedural requirements of the Paris Agreement, like reporting its domestic emissions and lodging periodic nationally determined contributions, are all that it's obliged by international law to be doing in the climate space. As Jen explained, the ICJ made crystal clear that much more is required. To begin with, the court concluded that all states have a binding international law duty to prevent significant harm to the climate system from man-made greenhouse gas emissions. And this is because Earth's climate system is fundamental to successful human existence. So this means that for Australia, that just going along as we are, exporting large quantities of fossil fuels, taking no responsibility for the damage they're causing to Earth's climate, and having no plan at all to address that, places Australia in clear violation of international law and international human rights law. Our third point is that the ICJ has also made clear that it doesn't matter where the emissions from burning our fossil fuels occur, here in Australia or overseas. The court expressly warned that failure by a state to prevent significant harm to the climate system, whether it results directly from that state's actions or from the actions of fossil fuel corporations operating from its territory, may constitute an internationally wrongful act which is attributable to that state. So if I can just draw out this point, the wrongful act is not the act of emitting greenhouse gas emissions per se. It's the breach by Australia of its international law obligation to protect the climate system from significant harm resulting from greenhouse gas emissions which are under its control effectively. Now, Australia has fought really hard over this issue, but the law is now beyond argument. Australia is responsible if it's failed to take actions reasonably available to it to prevent significant climate system damage caused by fossil fuels produced by companies operating from its territory. It's worth noting too that close to 2/3 of Australia's fossil fuel exports go to Japan, Korea and Taiwan, countries in the very top echelons of income and development globally. And it's now clear that these buyer states may be similarly liable under international law for their failure to prevent significant harm to the climate, especially Japan, which on-sells to other lower income countries so much of the gas that it buys from us. Our fourth point is that states are required by international and human rights law to undertake a series of steps to comply with those legal obligations. This was referred to by Jen and is known as states undertaking their due diligence to ensure they're meeting their legal obligations at all times. Due diligence has to begin with investigation, with finding out exactly what harm is being caused to the climate system and to people and to their human rights by actions in a state's own territory or under its control, and what's being done to prevent that. States must then use, and I quote, all means at their disposal, including, importantly, the adoption of appropriate rules and measures to prevent activities carried out within their jurisdiction or control from causing significant harm to the climate system. Highly developed, high fossil fuel producing states are required, as the ICJ made clear, to adopt particularly strong and effective rules and measures. Australia is one of those states. And all states must design these rules and measures, and again I quote, to ensure the deep, rapid and sustained reduction of greenhouse gases necessary to prevent that harm. In light of that, our fifth point is that in state of denial, we've set out the minimum steps which Australia is obliged to take if it's to comply with international and human rights law, including those due diligence obligations. So step one, it must establish an immediate moratorium on approvals of new or expanded fossil fuel export projects and subsidy grants, pending decisions made in the course of its stringent due diligence investigation. Step two, It must immediately begin its due diligence, and this involves undertaking a comprehensive assessment of the contribution of the fossil fuel exports to climate harm and climate-related human rights harms in Australia, including, the ICJ made clear, historical, current and projected total exported fossil fuel emissions and their temperature effects. It includes Australia conducting a review of its current policies and regulation, or absence of those, at both the national and subnational levels of the fossil fuel exports. And it involves identifying the steps it could reasonably and effectively take to minimise or reduce those climate and human rights harms. Step 3, it must develop a regulatory and policy reform package incorporating all, and these are words from the ICJ opinion, necessary, adequate and appropriate measures and policies to protect the climate system and human rights in Australia. It must implement an orderly but ambitious plan for a fossil fuel exports phase out for Australia in bona fide cooperation with stakeholders, including those buyer countries I mentioned earlier. And it must pursue a process of consequential legislative reform. And step 4, it must ensure that these reform processes fully incorporate human rights principles. There's so much more to be found in State of Denial and in the summary report, and we encourage you to download them and to support us in calling on governments in Australia to come in from the cold, abide by international law and respect and protect our human rights. Thank you.
Thanks so much, Nathan and Gillian, for taking us through the report and the national guidance. We'll now turn to Chris. Chris, what implications do you see the ICJ advisory opinion having for climate litigation in Australia specifically?
Thanks for asking, Maria. I'm conscious of time. I'm happy to cede my time to hear more from Jen. I'm not sure how you'd like me to proceed. I'm just in your hands.
We're very happy for you to speak as planned, Chris.
Okay.
So go ahead.
Well, I'll try and just make a few points and answer your question. And can I begin by acknowledging I'm speaking from the lands of the Turrbal and Jagera peoples? I also want to start by congratulating Gillian and Nathan on such an important report. I look at your recommendations, like your first recommendation about a moratorium on new fossil fuel projects, and completely agree with them from a legal and scientific perspective. At the same time, they're also a complete anathema to current Australian and state governments. We've got massive regulatory capture in Australia by the gas and coal sectors, and if you walked in and made that recommendation in a minister's office in the in the Commonwealth or Queensland or New South Wales or WA and said we've got to have a moratorium on coal and gas, they'd be calling for security that there's a crazy person in their office. So when I look at your recommendations, I more think of them, and I would think this is a good metaphor for them, like they're a compass. They're a compass of where we should be heading, of where Australia will need to go in the future, not what's currently politically tenable, but a compass for the future. So congratulate you on your important report. Also, as a preliminary point, make the point that I feel like a Taylor Swift fan presenting alongside a superstar with Jen. I've got a number of, amazing international lawyers and others, leaders at the Australian bar who are fantastic and really admire, and Jen's right up there. So lovely to see her and honor to present with her. And thinking of superstars, I had the pleasure of going to a Paul Kelly concert in Brisbane on Friday night. And for me, my favorite part of the concert was him singing "From Little Things, Big Things Grow." And as I'm sure virtually everyone knows, all Australians, it's a story about the song and a story about the Gundiri people and their fight for land rights that started in really 1966, and then took 8 years before Gough Whitlam travelled to their country. And there's that line in the song where he pours sand into the hand of Vincent Lingari, signifying the return of their land. And I really feel like the ICJ decision is like that pouring of sand into the hands of the people of Vanuatu and others who are harmed by climate change. It's such an enormous moment in history. And from that 1975, we still see such a struggle for First Nations people in Australia and elsewhere. So it's an ongoing battle, and it's a story that we continue to tell, but this is an absolute high point. Now, you asked me to talk sort of from a domestic level, and prior to speaking, I was asked to really think about Queensland in particular, because we're the main coal state. We've also got a huge amount of gas exports. We've got a Human Rights Act that came in 2019. But I want to make a broader point, which I think is relevant to all Australian domestic courts, which is, I think the massive influence that this decision will have is, and it's going to be a strong influence on Australian domestic courts, it's changing what is normal and acceptable conduct for courts and others. Because 10 years ago, as short a time ago as 10 years ago, when we were fighting, say, against the Adani coal mine here in Queensland, it was still so difficult to go in and say to the court, we shouldn't be allowing this massive coal mine to go ahead because of the climate change impacts. And we've had some big steps forward since then, with Chief Judge Preston's incredible decision in Rocky Hill in New South Wales. We've had President Kingham's decision in Waratah Coal, but still Queensland and New South Wales and WA governments and the Commonwealth are approving coal and gas projects as much as they can. And you made the point that we don't have any sort of proposals to close them down, but our actual plan is to exploit everything that's economically recoverable. Like, really think about our current policies, it's to basically dig it all up and party on. So I think broadly it's sort of the ICJ decision is shifting the window of what is acceptable and normal. We're going to see it play out in some decisions, I think, pretty early. At the moment in Queensland in the Land Court, we've got a big case that's been run by ACF and Mackay Conservation Group with some fantastic, the Environmental Defenders Office of their solicitors. They've got Emrys Nekperville, arguably one of Australia's best human rights lawyers. He's a fantastic silk, leading a great legal team, and they are obviously fully across the ICJ. Admittedly, they're against Saul Holt, who, I love Saul, and he's an incredible lawyer. Ironically, Saul was the barrister with Emrys in the decision about Waratah Coal, where the President Kingham recommended against approval of a coal mine because of its partly because of its climate change impacts. Now Saul's for the mining company, Emrys is for the conservation groups. It's a really interesting, they're both such fantastic silks. But we've got a member of the Land Court who's going to be called upon to consider the ICJ decision in the context of human rights, the context of an approval of a massive coal mine. And where I think it's really interesting is actually more fundamental than human rights, because we've got human rights legislation only in a few Australian states, Queensland being one of them. New South Wales, no. WA, no. But really, one of the big changes that the ICJ decision makes, I think, is to the public interest test, which is fundamental in so much. It's ubiquitous virtually across Australian domestic legislation. An idea that when a decision maker is approving a big project like a coal or gas project, they have to weigh up the public interest. And that traditionally allows a decision maker to weigh up the pros and cons. And it's sort of this sort of melting pot, where a black box as well, for a decision maker to, see what they think is the benefit of this project as opposed to its environmental impacts. And what the ICJ decision now is doing is changing the equation, because in the past you could look at the jobs and the money that would come from coal, and you get the quantifiable dollar value of that, and the job, maybe it's 1,000 jobs and $1 billion in royalties. But on the environmental side, it's relatively qualitative and difficult to quantify in the negative. But now, if we have to think, Australia has to really be thinking about reparations and paying the cost of exports, and that fundamentally should change how our decision makers approach the public interest test. Because now, if we prove a coal mine, potentially we are liable internationally. Enforcing it obviously is a challenge, but changing that public interest test is has a massive impact for Australian domestic decision makers generally. I just make that point. I want to wrap up. So excited to see the Pabbi and Commonwealth appeal if that goes ahead, because that decision said Australia's Commonwealth doesn't have a duty of care for First Nations people in the Torres Strait under Australian common law as it currently stands. A week after that, we got the ICJ decision, and it has really set up a fabulous contrast between Australian common law and international customary law. And in the past, like in Mabo, one of the things that really influenced the change in Australian common law was the international customary law component around terra nullius. So I'm really hopeful that if the Pabbi decision is appealed, we will see a shift in the Australian common law around, the concept of the duty of care and what's required in relation to this existential threat in relation to climate change. So yeah, some incredible implications from a domestic court's perspective, but also decision makers' perspective. And yeah, wrap up by saying thanks again for your fabulous report. I do see it as a compass for the future for where Australia should be heading from a policy perspective. So hand back to you, Maria.
Thanks so much, Chris. As we conclude tonight's discussion, I want to thank our panelists for their insights and all of you for being here. We encourage you to read the report, State of Denial, share it widely, and carry these conversations into your own networks. On behalf of the Australian Human Rights Institute, thank you for joining us, and we wish you a good evening. Thanks so much.